Good evening, ladies and gentlemen. On behalf of Supreme Court Advocates on Record Association, I extend a warm welcome to all of you. We are deeply honored by the gracious presence of Honorable Mr. Justice Suryakant, the Chief Justice of India, Honorable Mr. Justice Vikram Nath, Honorable Mrs. Justice V. Mohana, Justice Varare, from the judges of the Supreme Court of India attending the functions today. I warmly welcome our distinguished international guest, Honorable Mrs. Justice Abha Nayar Patel, Judge of the Supreme Court of Zambia. We are truly honored by your presence, delighted to welcome you here in the Supreme Court of India and to the Skora family. I also welcome family member of Justice Patel present today, Ms. Vibha Chopra. Welcome, ma'am. I welcome past President, Vice President, Mr. Snehashish Mukherjee Skora, Secretary, Ms. Nandini Gore. I welcome Munaindi Vestanathan and Gauri Sabaya from the Malaysian Bar. They were to reach today. From team SCBA, I think we have Minish, who is the Joint Secretary CBA. I welcome all the learned senior advocates present here, esteemed guests, and fellow members from my bar, and the media as well. Welcome, everybody. As a symbol of our gratitude, we would like to welcome the distinguished dignitaries with a planter. I request Mr. Rahul Gupta to present a planter to Honorable Mr. Justice Suryakant, the Chief Justice of India. I request Mr. Sudarshan Ranjan to present the planter to Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India. I request Mr. Gautam Das to present a planter to Honorable Mrs. Justice V. Mohana, Judge, Supreme Court of India. I request Ms. Shrishti Mishra to present a planter to Honorable Mrs. Justice Abha Nayar Patel, Judge, Supreme Court of Zambia. Thank you. Today's lecture on future of the justice delivery system, innovation, inclusion, and integrity reflects Skora's continuing commitment to creating meaningful opportunities for a dialogue. Opportunities to ask, how do we strengthen our justice delivery system? And one way is by learning from judicial experiences across different jurisdictions. Now, what makes today's lecture particularly special is that we have the privilege of hearing perspectives from two different legal systems. India and Zambia, separated by geographies, yes, but our legal systems, they overlap in a meaningful way. Both are rooted in common law traditions, both shaped by shared colonial legacy, both guided by same fundamental values, the rule of law, judicial independence, fairness, and due process. It is this shared foundation on one hand and this distinct experiences on the other that makes today's exchange of ideas especially valuable. To further this dialogue, I invite Mr. Nikhil Jain, Vice President Skora, to give us an insight in the life of Justice Patel and to give his welcome address.
Honorable Mr. Justice Suryakant, Chief Justice of India, Honorable Mrs. Justice Abha Nayar Patel, Judge, Supreme Court of Zambia, Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, Honorable Mrs. Justice V. Mona, Judge, Supreme Court of India, Honorable Justice Varale, Judge, Supreme Court of India, respected office bearers and members of Skora, senior advocates, family members of Justice Patel, Mr. Minish Dubes, Joint Secretary Skora, distinguished members of the bench and the bar, ladies and gentlemen. Good evening, everyone. It is my privilege on behalf of Skora to extend a very warm welcome to all of you to this special lecture on the future of justice delivery, innovation, inclusion, and integrity. We are particularly privileged to have with us this evening Honorable Mrs. Justice Abha Nayar Patel, Judge Supreme Court of Zambia, whose distinguished journey in the legal profession reflects a remarkable combination of professional excellence, judicial service, and a sustained commitment to the evolution of justice delivery. After almost 3 decades in private legal practice, your ladyship served as judge in charge of the commercial division of the High Court of Kitwe, thereafter served as a judge of the Court of Appeal, and was most recently elevated to the Supreme Court of Zambia in May 2026. She also holds the distinction of being the first woman of Indian origin to serve on the bench in the Republic of Zambia. Your ladyship's contribution extends considerably beyond the courtroom. She is a fellow of the Chartered Institute of Arbitrators and an accredited commercial mediator with extensive experience in mediation, arbitration, and ADR training. Her work in judicial training and capacity building across Africa, together with her role as chairperson of the Chief Justice's Advisory Committee on Record, Annexed Mediation and Delay Reduction, makes her experience specially relevant to the subject before us this evening. I had the privilege of meeting your ladyship only a few days ago at the Commonwealth Peace Mediation Conference at Jaipur. It is wonderful to have that conversation continue here today in a different setting, but around a question that concerns every institution involved in the administration of justice. What would the future of justice look like? And when we think about that future, 3 words immediately stand out: innovation, inclusion, integrity. Innovation is already transforming the manner in which justice is administered. E-filing, virtual hearings, live streamings of constitution bench proceedings, digital case management, and modern mechanisms of alternate dispute resolution have created possibilities that would have been difficult to imagine only a few years ago. That conversation has now arrived at artificial intelligence. AI is already at work within our justice system in the transcription of oral proceedings and the translation of judgments into Indian languages. Used well, these tools can significantly reduce pendency in the Indian judiciary. But AI in the courtroom also raises important questions of explainability, data protection, and confidentiality. SCORA has engaged closely with these questions, most recently through its comments and recommendations on the draft regulations governing the use of artificial intelligence in courts. This engagement reflects the association's larger role in contributing constructively to the evolution of justice delivery. Inclusion reminds us that the ultimate purpose of every reform must be to ensure that justice reaches everyone. No technological or institutional advancement can truly be called progress if geography, economic circumstances, disability, or lack of digital access keep a litigant away from justice system. As we embrace technology and new models of justice delivery, we must ensure that innovation does not create a new divide. The future of justice must not only be faster and more efficient, but also more accessible, equitable, and humane. And then there is integrity, the principle that must remain constant irrespective of how much the institutions around us change. Technology may transform our courts, procedures may evolve, new mechanisms of dispute resolution may emerge, but the independence of the judiciary, fairness of the process, and confidence of the litigant in the institution of justice can never be compromised. In many ways, your ladyship's own professional journey brings these 3 ideas together: innovation through her extensive work in mediation and ADR, inclusion through her commitment to access to justice and delay reduction, and integrity through a distinguished career at the bar and on the bench. Your ladyship, we are truly privileged to have you with us this evening. Your experience across adjudication, mediation, arbitration, judicial training, and institutional reform will bring a valuable international perspective to this important conversation. It is equally a privilege to have with us this evening Honorable the Chief Justice of India, Justice Suryakant, Justice Vikramnath, Justice V. Mona, Justice Varale, and the members of the bar. Your presence adds greatly to the significance on this occasion. As we look towards the future of our justice delivery institutions, there is perhaps one thought that comes to my mind, one that I believe we should carry with us. The future of justice will not be defined merely by how advanced our courts become, but by how fairly, how inclusively, and how humanely they deliver justice. Let innovation be our instrument, inclusion be our reach, and integrity be our compass. Thank you.
Thank you, Nikhil. May I request Devrat ji, President Skora, for his remarks.
Good evening, everyone. Honorable the Chief Justice of India, Justice Supremecourt, Justice Vikram Nath, Honorable Justice V. Mohana, Honorable Justice Varale, our former Vice President, Mr. Snehashish, Mr. Santhanam, Ms. Nandini Gore, and all the distinguished guests present here. Allow me to share how Justice Patel is here, as Nikhil has spoken about her career and everything, so I need not repeat the same thing. So we met her recently, as Nikhil said, in the conference in Jaipur. I was seated beside her when an organizer quietly approached her and handed over a note informing that she has to speak in the next session. I have seen her speaking in the inaugural session, where she was very eloquent and totally articulate, and so therefore this invitation to the next session was not in the schedule, so it was a surprise for her. So she told me that is a little surprising, but then she gathered her thoughts and she went to speak. She walked to the podium and completely commanded the room. I had already witnessed her earlier. She spoke extempore, just gathered her thoughts, something she wrote on a mobile phone. And so after the opening ceremony and all that, the warmth and poise, the kind of she crystallized the complex issues was something which was very appealing to me. So when she came back, I called her, our secretary Yugandhara, if we can arrange a program. She agreed, and she worked very hard for that. So because it was on a short notice, so we invited her to Skora. I'm delighted that she accepted our invitation. She's flying back tomorrow to Zambia. So now Nikhil has spoke about her journey, and it has become clear what we witnessed in Jaipur was entirely characteristic of her. So she moved to Zambia when she was 6 years old. As Nikhil pointed out, that she earned her LLM from the University of Cambridge, and then she was conferred the rank of State Counsel, served in the High Court and the Court of Appeal, and she is the first woman judge of the Supreme Court of Zambia. Her achievements speaks for themselves. What impressed me most was her humility. Despite all that she has accomplished, she carried herself with such ease and grace that one would never have guessed she had been asked to address a full hall with almost no notice. I must confess, her journey leaves us with one slightly envious reflection. Here stands a person of Indian origin, serving with distinction on the Supreme Court of Zambia. Perhaps one day, with an appropriate constitutional amendment, we too may have a privilege of seeing judges of Indian origin from across the world to adorn the bench of the Supreme Court also. Justice Patel, it's a privilege to welcome you to the Supreme Court of India, and also to the Supreme Court Advocates on Record Association. We are deeply honored by your presence, and we look forward to hearing your address. I would not be an obstacle between your address and the gathering. Thank you. Thank you.
Thank you, Devraj ji. It is my pleasure to invite Honorable Mrs. Justice V. Mohana, whom we all admire and adore, to address the gathering.
Honorable the Chief Justice of India, Justice Vikram Nath, Justice Varale, our special guest, Justice Abha Nayar Patel, the President and other office bearers of the SCORA, and ladies and gentlemen, my friends present here, a very good evening. First, let me congratulate Justice Abha. She has recently been elevated to the Supreme Court of Zambia. For that, we offer our congratulations. She was appointed as a judge on May 27, 26. Prior to that, she was serving in the Court of Appeal since 2023. She has had an illustrious career. Like our Devraj said, she has been an extempore speaker. She has been involved in many activities, and she has had a wonderful career as a lawyer as well. She is a source of inspiration for all the young and upcoming lawyers. When she was appointed as the State Counsel in 2016, she achieved the feat of being only the third woman advocate in Zambia to have done so. She was one of the first members of the Zambian bar to be trained in the ADR. She chairs the Chief Justice's Advisory Committee on Court Annex Mediation and Delay Reduction. She has ensured that several pending cases are successfully resolved in the mediation settlement works organized by the judiciary of Zambia. We have a similar system of Lok Adalats, which has been instrumental in delivering speedy justice. Justice Patel has been promoting inclusion and expansion of mediation within and outside Zambia. We are very proud to have you here, Ms. Patel. Justice cannot be truly inclusive if it is available only to those who can afford to travel to a court, engage a lawyer, or understand a complex legal system. Our constitutional framework has therefore consistently moved towards bringing governance and justice closer to the people. Mechanisms such as Lok Adalats, mediation, and other forms of alternative dispute resolutions have further enabled disputes to be resolved more quickly and closer to the people. Our Supreme Court has also recognized that the right to speedy trial and free legal aid are integral part of Article 21. Article 21 has over the years become an umbrella for a range of rights that give real meaning to the guarantee of life and personal liberty. But access to justice is not merely about physical access to a courtroom, it is also about having a voice within that courtroom. That's about inclusion. For a country as vast and diverse as India, technology can help overcome one of the oldest barriers to justice: distance. E-filing, virtual hearings, digitized records, and live streaming of Constitution bench proceedings have changed the way citizens interact with courts. Initiatives under e-courts phase 3, including electronic service of summons and the e-court services application, show how technology can make justice faster, more transparent, and more accessible. We now have online dispute resolution platforms and digital mediation offer cost-effective out-of-court settlement. The Supreme Court has also begun using AI-assisted transcription of Constitution bench hearings, and with the draft regulations on the use of artificial intelligence in courts, the court is beginning to confront an important question, not simply whether AI can be used, but how it should be used responsibly. The answer must always remain clear. AI may assist justice, but it cannot replace the human judgment that delivers justice. Human oversight, judicial independence, transparency, accountability, fairness, explainability, and protection of personal data must remain at the heart of technological innovation, which we are striving to do. Only when justice is truly accessible to all can the promise of our Constitution be fulfilled. Justice is not delivered by judges alone. It is delivered by an entire ecosystem working together. But judges occupy a unique position within that ecosystem because the legitimacy of judicial power rests ultimately upon the confidence of the people. We need to balance technological efficiency with fundamental constitutional values, ethics, and judicial independence to gain public confidence. The future of justice delivery, therefore, is not simply about building faster courts or adopting newer technologies. It is about building a justice system that reaches every citizen, listens to every citizen, and earns the trust of every citizen. Innovation can bring justice closer. Inclusivity can ensure that no one is left behind, but integrity is what makes the judges worthy of trust. I sincerely congratulate the SCORA for organizing this event, to felicitate our guest Ms. Patel, and for a continuing legal education on this topic. I thank the SCORA for this opportunity and all of you for being here on a Thursday evening despite all your commitments. Thank you very much.
Thank you, Ladyship, for those insightful thoughts. Especially justice delivery means justice accessible to all citizens. May I respectfully invite Honorable Mr. Justice Vikramnath to address us.
A very warm good evening to everyone present in this multipurpose hall. Honorable the Chief Justice of India, Mr. Justice Suryakant, my esteemed colleagues, Justice Varale and Justice Mohana, our special guest from Zambia, Justice Abha Nayar Patel, Judge Supreme Court of Zambia, President SCORA, Mr. Devrat, Vice President Mr. Jain, Secretary Ms. Pawar, learned senior advocates, learned members of the bar, guests from Malaysia, ladies and gentlemen. A small caveat before I start my address. I may be repeating a couple of things which have already been spoken by the previous speakers, but still I will tell you something more about Justice Patel today. It is a great pleasure to be here today, and particularly so in the company of Justice Abha Nayar Patel of the Supreme Court of Zambia. Justice Patel's journey is a remarkable one, which connects India and Zambia in a very personal way. She was born in New Delhi in 1966, and then she moved to Zambia early in life. She studied law there, where she graduated with distinction and remains the only woman from the law school to have done so. She then went to Cambridge for her master's. She joined the bar in 1989 and spent many years in practice and also ran her own law firm. Quite early in her career, Justice Patel developed an interest in alternative dispute resolution. She was among the first members of the Zambian bar to be trained in ADR, became a fellow of the Chartered Institute of Arbitrators, and has spent more than 2 decades training mediators for the Zambian judiciary. In 2016, she was conferred the rank of State Counsel, becoming only the 3rd woman in Zambia's history to receive that honor. She was appointed to the High Court in 2019, elevated to the Court of Appeal in 2023, and in May this year to the Supreme Court of Zambia, the first woman of Indian origin to sit on that bench. At the time of her appointment, she said that she received it, and I quote, "not with pride, but with deep reverence and a profound sense of responsibility." I find those words particularly appropriate for the conversation we are having today. We are living through unprecedented times. People today are far more aware of their rights and of the institutions which govern them. And this change was something which was long time coming. Institutions must be open to questioning. That is part of their strength, not a threat to it. But this growing awareness also brings with it a quiet weight. Expectations rise, and rightly so. If citizens are expected to respect institutions, then institutions must be equally willing to account for the power entrusted to them. Justice, fairness, and transparency cannot remain confined to the language of judgments, speeches, or statutes. They must be felt in the lived experience of those who approach the system. This assumes a special importance when we speak of courts. Courts are often described as guardians of rights. We use that expression so frequently that it is easy to forget what it actually asks of us. Liberty is not an abstract idea when you are in custody. Equality is not an abstract idea when you have been treated differently. The courtroom is where these promises of the law are tested against what has actually happened to individuals, which makes the responsibility even bigger. And I must add that responsibility does not belong to judges alone. Justice is a collective enterprise. Lawyers, court staff, and every person who participates in the process contributes to the experience of a litigant. A lawyer's duty does not end with securing a favorable order. There is a duty to the court and to the fairness of the process itself. Strong institutions are built on shared responsibility and understanding. At the same time, preserving these values cannot mean preserving every old method. As it was often said, change is the only constant. We have seen tremendous change in this regard. Digital records, virtual hearings, and more access to judgments and case information have opened many doors. New ways are being devised for dispute resolution, which have turned to be extremely effective and time-saving as opposed to traditional litigation. Justice Patel's work in mediation is particularly relevant here. For more than 2 decades, she has helped strengthen court-annexed mediation in Zambia. In India too, the Samadhan Samaroh reflects this recognition that every dispute need not go through the rigors of litigation before it can be resolved. The future of justice delivery is not about replacing everything we inherited with something new. It is about knowing what should change and what should not. The pursuit of accountability and transparency cannot itself become the reason another person's rights are compromised. The challenge for the future, therefore, is not simply to make justice more visible, but to make it more open without hindering rights of others. Before I conclude, there is another side to Justice Patel which I cannot resist mentioning. A few years ago, she climbed Mount Kilimanjaro for charity. I confess that when I came to know about this, I thought that after running a law firm, spending decades at the bar, and then becoming a judge, perhaps Kilimanjaro seemed like the obvious next challenge. Her journey from private practice to now as judge of the Supreme Court of Zambia is a fitting one to reflect upon as we discuss where our justice systems go from here. The institutions we inherited will change. They must. But as they become faster and more innovative, our task is to ensure that they also become more responsive and more accountable, worthy of the faith that people and the Constitution put in them. Thank you very much.
Thank you, Lordship, for your inspiring address. So every time today it has been mentioned that Justice Patel is the first Indian origin judge on the bench of Supreme Court of Zambia, there has been a great applause, which shows how proud we are. She carries forward the legacy of the people of Indian origin with legal background who have made mark within the African continent, a trend which Mahatma Gandhi had started. With that, I request Mrs. Abha kindly come and address us.
Good evening to you all. I bring with me the greetings from the Honorable the Chief Justice of the Republic of Zambia, Dr. Mumba Balila, State Counsel. My Lord, the Honorable Chief Justice of India, Honorable Mr. Justice Suryakant, Honorable Mr. Justice Vikramnath, My Lady Honorable Mrs. Justice V. Mona, all honorable judges present, the President, office bearers, and executive members of the Executive Committee of the Supreme Court Advocates on Record Association, senior advocates, colleagues at the bar, allow me simply to say, distinguished ladies and gentlemen. Honorable Chief Justice, I am humbled at this invitation to spend some time with you all, acknowledging that I have been overwhelmed with the love and attention that I have received over the last few days at the Commonwealth Peace Mediation Conference, which culminated in the signing of the Jaipur Declaration 2026. I come before you today in peace and a heart full of gratitude. I thank the organizers for putting this event together in such a short time, and I remain ever so grateful for this gift of time which you have all bestowed on me today. Time is something we do not take for granted. I'm also delighted at the subject of this conference, and I'm glad you've reined me in, otherwise I would talk about everything else. So we're here to talk about the future of justice delivery. And we've heard from the first speaker that innovation, integrity, and inclusivity sit at the very heart of justice delivery. The future of justice delivery, my lord, is a fundamental issue to all stakeholders in the justice delivery system. It affects me, it affects you, and it affects the litigant who has a constitutional right to seek justice. As I sat to prepare my thoughts, with a little more time than I had for the valedictory session on this issue, I realized the depth of this topic as it sits at the heart of what we do. Not merely how justice is delivered today, but how it must evolve to remain worthy of public trust tomorrow. The theme before us, innovation, integrity, and inclusivity, is not three separate conversations stitched together for convenience. It is one conversation viewed from three dimensions. Innovation, I submit, without integrity is dangerous. Integrity without inclusivity is incomplete. And inclusivity without innovation is often too slow to matter. Today, I want to offer my thoughts on how these three ideas must move together as a single current if justice delivery is to serve the turbulent times ahead of us. When we speak to innovation, we've heard the tools are changing, but the duty, I submit, is not. Let me begin with innovation because it is the most visible and for many, the most unsettling of our time. Across the world, judiciaries are experimenting with case management systems, e-filings, virtual hearings, AI-assisted legal research, and predictive analytics for case flow. Some jurisdictions have gone further still, piloting AI tools to assist, but never to replace judicial reasoning in high-volume, low-complexity matters. In my own region in Zambia, we are taking slow but meaningful steps towards digitization of court records and virtual testimony, born partly of necessity during the pandemic years, but now recognized as tools of genuine access. The case for innovation is not novelty for its own sake. It is a case about delay. Justice delayed is not simply an inconvenience. It is, as we all know, a form of injustice in itself. A litigant who waits for years for a judgment has in a very real sense been denied the very thing the courts exist to provide. As the enduring maxim reminds us, justice delayed is justice denied. Timeliness is therefore not merely an administrative virtue, it is an essential part of justice itself. This is not an abstract concern in our own jurisdiction. Our civil procedure in Zambia prescribes that matters ordinarily proceed from the close of pleadings to trial within a matter of months. And our commercial courts have shown that when case management is disciplined, timelines can be honored. Yet, in more complex high court and appellate matters, the gap between that procedural promise and lived reality remains a challenge. And we must continue to close that challenge. Backlogs erode public confidence far more corrosively than any single controversial ruling of the court. Technology, used widely, is one of the few tools that we can meaningfully compress the timeline without compromising or compressing the quality of justice itself. But I submit that where there is innovation, it must be held to account. Technology in a courtroom is not a neutral instrument. An algorithm trained on historic sentencing data will reproduce historic biases unless we build the safeguards to prevent it. A virtual hearing may expand access for the litigant with a smartphone and a stable internet connection, while silently excluding the litigant who has neither. Innovation unexamined does not eliminate inequality, it can simply digitize that inequality. That is why every innovation we adopt in the justice sector must pass through two filters before it reaches the courtroom. Does it improve the fairness of the outcome? And does it improve access to that outcome for those who need it the most? If a tool fails either of the two tests, it is not yet fit for judicial use, no matter how impressive its engineering. Let me turn to integrity, which I submit is the anchor that cannot move. This is the anchor that points around which all reform must turn. Integrity in judicial life is sometimes spoken of narrowly as the absence of corruption. That is necessary, but it is not sufficient. Integrity, properly understood, is the sum of independence, impartiality, accountability, and transparency, sustained not merely in outcome, but in process visible to the litigant that stands before the court and visible to the public that has never set foot inside the court. Supreme Courts have over the years had cause to weigh the constitutional guarantees of due process and fair hearing against the practical realities of governance and procedure, reminding us in cases touching on the protection of fundamental rights and freedoms that the value of a right is measured not by its declaration alone, but by the rigor with which the institutions defend it in practice. As we adopt new tools, integrity demands a new vigilance. If an AI system assists into legal research or a case triage, who audits that? If a matter is heard virtually, how do we preserve the solemnity and gravity that a courtroom setting confers upon proceedings so that justice is not merely done, but it is felt by every litigant? If predictive analytics inform how cases are prioritized, what prevents that prioritization from quietly favoring the well-resourced litigant who can navigate the system over the unrepresented one who cannot? I would suggest that integrity in the coming decades will not be won through resistance to change, but through governance of change. We need clear judicial and professional standards for the use of technology in our courts, and standards developed by the judiciary itself, not imposed upon it from outside, and not left to develop merely by accident. This is where collaboration across jurisdictions, shared learnings, and judicial networks and alliances have an important role to play, developing shared standards of practice so that innovation in dispute resolution, whether in court or in arbitration and mediation, does not outpace the ethical scaffolding meant to hold it up. Integrity, I add, is a discipline of humility. It requires us, the judicial officers, to say clearly, this tool assists my reasoning, but the reasoning and the responsibility remains mine alone. That principle must never be permitted to erode, no matter how sophisticated our instruments become. At the same time, we expect the bar to take a lead role to mentor and develop the ethical and regulated use of these tools so that they are used to assist and not mislead the court. AI hallucination is real. The courts are dealing with it amid challenges of resources, infrastructure, and capacity. This brings me to talk about inclusivity. And I want to be direct about what I mean by the word because it is too often reduced to a slogan. Inclusivity in justice means that the woman in a rural district who has never seen the inside of a courthouse can nonetheless understand what her rights are and how to assert them. It means that language, literacy, disability, distance, and cost do not quietly determine who receives justice and who does not. It means representation on the bench, at the bar, and within the institutions that shape legal policy that reflect the societies these institutions serve. Much has been said about me already, and much has been said about me being the first woman of Indian origin. And I was very humbled that Justice has actually recounted and recited my words, so I will not go there again. This is not merely a personal milestone. It is a door opened by God's hand so that others may walk through it. It reminds us that grace does not discriminate and that purpose and service knows no boundaries. When one has spent a career in the corridors of the law, moving as many of us in this room have, from advocacy at the bar to the bench of the trial courts, through appellate benches and into the highest reaches of judicial service, one learns that recognition of this kind is rarely about that individual. It is a recognition of the institutions we serve, the traditions we inherit, and the values we are simply entrusted to protect for the next generation. When I think of the women who broke ground before us on the benches of this continent, women who sat as not only the only woman or the only judge of their background, in rooms that were not built with them in mind, I'm reminded that inclusivity is not a modern invention. It is unfinished business, generations in the making, and it remains ours to carry forward to its logical conclusion. Mediation and alternative dispute resolution deserve particular mention because they are at their best tools of inclusivity. In practice, forums that can be less costly, less intimidating, and more responsive to the lived realities of the parties before them, provided they too are held to ethical, rigorous standards of fairness and are not permitted to become a lesser justice. Case management skills, timelines, and formal rules assist adjudicators in dispensing justice in a clear and transparent manner and must be seen as tools of inclusivity. Inclusivity in the future we are building must also mean cross-border and cross-cultural fluency. Disputes increasingly cross-jurisdiction. Litigants are increasingly coming from a diaspora, communities with ties to more than one legal culture. I perhaps am the best example that stands before you today. A justice system fit for the future must be capable of speaking to and being understood by a public far more mobile and far more interconnected than one our founding legal frameworks were designed for. In conclusion, let me draw these three threads together. Innovation without integrity risks building faster paths to unjust outcomes. Integrity without inclusivity risks preserving a system that is honest, but only honest for those who can reach it. And inclusivity without innovation risks good intentions that arrive too late to matter in a world moving faster than our institutions. The future of justice delivery will not be won by choosing between these three values. It will be won by judicial leadership and by all of us in this room insisting that they advance together. That every new tool we adopt is tested against fairness. Every reform we pursue is measured against reach, and every efficiency we gain is never purchased at the cost of the public's trust. This is not an easy balance to strike, my lord. But it has never been the business of this profession to choose the easy path. It has always been our business to choose the correct path. On that note, let me thank you all for your attention and for this very generous invitation.
Thank you, Ladyship, for your reflections. Now we know why everybody has been praising about your speech and your talks. You have interwoven the theme so graciously and so well and connected all the dots for all of us. I'm just going to take a moment to warmly welcome all our viewers watching on the YouTube channel. Welcome and keep watching us. It is my privilege and honor to most respectfully invite Honorable Mr. Justice Suryakant, Chief Justice of India, to deliver his address.
Justice Vikram Nath, Senior Most Judge, Supreme Court of India and Executive Chairman of the National Legal Service Authority. My esteemed colleague, my brother Justice Prasanna Abrale, my sister Judge Justice V. Mohana, both Judge Supreme Court of India, our distinguished guest, Honorable Mrs. Justice Abha Nayar Patel, Judge Supreme Court of Zambia, Mr. Devarth, President Supreme Court Advocates on Record Association, Mr. Nikhil Jain, Vice President SCORA, Mrs. Yugandhara Pawar Jha, Honorary Secretary SCORA, members of the Executive Committee and other office bearers of SCORA, very distinguished senior advocates, Sri Santhan Krishnan, Life President of the Commonwealth Lawyers Association, distinguished members of the SCORA and the Supreme Court Bar who are also gracing the occasion, respected sister of Justice Abha Patel, ladies and gentlemen, very good evening to all of you. Having heard the thought-provoking speech of our distinguished guest Justice Abha Nayar Patel and very eloquent addresses by my brother Justice Vikram Nath and Sister Justice V. Mohana on the future of justice delivery, innovation, inclusion and integrity, I must compliment them for not merely identifying the challenges confronting judiciary in the 21st century, but for reminding us that innovation drives its true meaning only when it serves inclusion and remains anchored in integrity. While technology may differ and institutions may evolve at different paces, the aspirations that unite our courts remain strikingly similar, namely, to build justice systems that are more accessible, more responsive, and more deserving of the trust that society reposes in them. It is in that shared spirit that I would like to briefly reflect upon the Indian judiciary's own journey of technological transformation. Over the last 2 decades, our endeavor has not been to make courts more technological for their own sake. Rather, it has been to make them more accessible, more transparent, and more responsive to every stakeholder who interacts with the justice delivery system. Technology, in our own understanding, is not an end in itself. It is an instrument that enables courts to fulfill their constitutional responsibility more effectively. Allow me to illustrate just how dramatically this transformation has unfolded. I do recollect when I joined the bar and started practicing in the High Court. Something as routine, we will find out that one matter will be called required considerable effort. The cause list existed only in physical form, pasted outside the courtroom on a door, and if you happen to have matters listed before different benches, you would often find yourself hurrying from one end of the court complex to the another simply to check the progress of the court cases. Today, the same information is available on the palm of your hand. A lawyer sitting anywhere in the country can access not only the cause list of virtually and any court, but also ascertain which matter is presently being heard. A mobile phone is sufficient, which will provide you this information within seconds. That seemingly simple change tells us a much larger story about how far our justice system has travelled so far. What began with the digitization of court processes has gradually evolved into the creation of a truly integrated digital justice ecosystem. Through the e-court mission mode project, which my brother Justice Vikram Nath looks after, being chairman, electronic filing, digital case management, online access to court records, video conferencing, and virtual hearings have become integral features of judicial administration across the country. I believe this transformation has benefited every participant in the justice delivery system, albeit in different ways. For judges, digital case management systems and electronic records have significantly reduced administrative burdens, allowing greater time and attention to be devoted on adjudicatory process. Additionally, the National Judicial Data Grid captures real-time information relating to the pendency and disposal of cases across thousands of courts in India, enabling us to identify trends, allocate resources more efficiently, and adopt data-driven solutions to long-standing challenges. The bar is also benefited. How? It has been benefited immensely from this digital evolution. Technology has reduced routine procedural burdens while simultaneously expanding access to legal resources and research tools. An advocate practicing in a smaller town nowadays enjoy access to digital libraries, electronic databases, and sophisticated legal research facilities that are once the reserved only for the metropolitan cities. In that sense, technology has helped level the playing field and democratize professional opportunities within the legal profession. Perhaps the greatest beneficiaries are the litigants themselves. They are able to track the progress of their cases online, participate in virtual proceedings before the court consent, and obtain essential legal information without undertaking costly and time-consuming travel. A citizen situated hundreds of kilometers away from New Delhi can effectively participate in proceeding before the Supreme Court without even crossing the threshold of the court. And as Justice Abha Nayar would particularly appreciate, given her distinguished contribution to the field of mediation, technology has also transformed the manner in which consensual dispute resolution is now undertaken. Increasingly, online mediation has enabled parties separated by geography to come together on a virtual platform, often making settlement quicker, more convenient, and considerably less expensive. When viewed together, these developments underscore that the true measure of technological process lies not in the sophistication of the software we create, but in the extent to which it makes justice more accessible, more affordable, and more comprehensible for those whom our courts ultimately exist to serve. As the next phase of this journey unfolds, artificial intelligence presents unprecedented opportunities for improving judicial administration. Yet, as I have consistently observed in many of my lectures and addresses on this subject, artificial intelligence may augment judicial intelligence without replacing the judicial consensus. Technology can process information with remarkable speed, but justice ultimately demands wisdom, empathy, and the exercise of reasoned human judgment. For this point, I would request all of you, and I believe that members of the bar must have gone by now, the draft AI regulations which we have displayed on the website of the Supreme Court, inviting your suggestions. The entire framework of the regulations will show that how the use of artificial intelligence has been ensured only for the purpose of assisting the justice delivery system and not allowing it to overpower and or to overtake the decision making process by the human judges. And the privacy, the safety of data, all safeguards have also been duly incorporated in those regulations. With this framework, the Supreme Court of India has introduced several initiatives besides the regulations that I am referring to and the consequential steps that we will take. All of you are aware of SUVAS, our AI-enabled translation software that seeks to overcome linguistic barriers by making judicial decisions available in multiple Indian languages. We have been right now successfully been able to translate our judgments into 16 regional languages, and I am quite sure right now the progress that is taking place, we will be able to very soon translate our judgments into all the recognized regional languages. We have also developed Su-Sahay that provides litigants, lawyers and members of the public with information relating to court procedures, filing requirements and case status through a very simple conversational interface. Similarly, that One Case One Data initiative aims to create a single standardized digital record for every case, improving consistency, reducing duplication and strengthening the reliability of judicial information across multiple platforms. With this one case and one data, while sitting in Supreme Court, the registry or my colleagues in Supreme Court will be able to, with the one click of button, find out what is the status of a particular case even in the trial court. And from here we can even manage and monitor the proceedings that's happening at different levels of the court. That's also been able to help us in avoiding duplicacy and multiple numbering of the cases, though originally it's one civil suit, say for example, but ultimately by the time it ends, it leads to according different kind of numbers at district court level, that district judiciary, then high court and then Supreme Court. Now one case and one data will ensure that the entire history of that case is digitized properly before us. The greater the capabilities of artificial intelligence, the greater is our responsibility to ensure that its use remains transparent, accountable and firmly subject to human oversight. It is precisely with this objective that our regulations will take care on this part of the safety, and while recognizing the source of information to streamline the administrative processes and also to ensure that it cannot assess credibility, appreciate evidence, exercise judicial discretion, these regulations will comprehensively deal with every aspect of artificial intelligence. If there is one lesson that India's experience has taught us, it is that technology and human values are not competing ideals. On the contrary, when responsibly deployed, technology strengthens the very values that sustain the administration of justice. Technology enables courts to become more inclusive without compromising integrity and more efficient without sacrificing fairness. It is in this spirit that I congratulate our distinguished guest, Justice Abha Nayar Patel, for evoking this very important conversation today. As judiciaries across jurisdictions continue to learn from one another's experiences, I am confident that we shall build justice systems that are not only more innovative, but also more accessible, more human, and more worthy of the trust that our citizens repose in them. I congratulate SCORA, its office bearers, for in taking this initiative and on a very short notice inviting Justice Abha Patel to share her views and giving this opportunity to all of us to speak about a subject which is very close to our heart and which is our constitutional duty. Thank you very much.
Thank you, Lordship. Your guidance and vision will undoubtedly continue to inspire us. As token of our affection, admiration and gratitude, SCORA would like to felicitate Honorable Mrs. Justice Abha Nayar Patel. May I request Mr. Devrat and Mr. Nikhil to kindly present the memento and a copy of our Constitution to Honorable Mrs. Justice Abha Nayar Patel. May I request Mr. Rohit Kumar Singh, Joint Secretary, SCORA, to propose a vote of thanks.
Respected dignitaries, distinguished guests, and esteemed colleagues. As Martin Luther King Jr. famously said, injustice anywhere is a threat to justice everywhere. This famous line written from the Buckingham jail. These words explain that all people are connected and harm to one person hurts everyone. As we reflect on the future of justice delivery system, innovation, inclusion, and integrity. It is a privilege to deliver a vote of thanks on behalf of the entire team of Supreme Court Advocate on Record Association. First and foremost, we express our deep gratitude to our Speaker, Honorable Justice Abha Nayar Patel, Judge, Supreme Court of Zambia, for sharing her invaluable prospects of modernizing legal system. Justice Abha Nayar Patel being the first woman of Indian origin to hold this position in the Honorable Supreme Court of Zambia, it gives us immense pride and honor to have you as our guest in today's function. Our sincere thanks to the Honorable Chief Justice of India, Justice Suryakant, for agreeing to preside over today's function. Your presence reminds us of Hon'Ble one's words. It is the spirit and not the form of law that keeps justice alive. We also extend our earnest appreciation to our guest of honor, Honorable Justice Vikram Nath sir, and Honorable Justice V. Mohana ma'am, Judges Supreme Court of India, for honoring and gracing this presence. I also thank Justice Varale for making their presence felt here. I also express my great gratitude to Mr. Manish Dubey, Joint Secretary, Supreme Court Bar Association, and Ms. Manika Goswami for being present here. I also give my hearty thanks to Ms. Anveshwar Gupta sir, Ms. Subhashish Mukherjee sir, and Ms. Nandini Gore ma'am for agreeing to be present here for the occasion. I also express my gratitude to the Committee of Supreme Court Advocate on Association Record, led by our President, Mr. Devrat, Vice President Nikhil Jain, Honorary Secretary Yogendra Bawa Jha, Treasurer Aljo Joseph, and Joint Treasurer Pallavi Barua, and all the executive members for their dedication for bringing this meaningful assembly together. I also thank the friends from the media, especially Mr. Ashish Bhargav, for being there. Finally, a heartfelt thanks to all the advocates and distinguished for being present today. Thank you all once again, and we cordially invite all the EC members for a stage photograph.
And Justice Varale.
And Justice Varale. Better than. Now I invite all members for a tea, high tea. Thank you so much, sir, for coming, sir.